Alright, folks, new headline. Well, not that new, it's like a few days old, but it was brought to my attention very recently because I'm an idiot and I don't really follow social media. Okay, so the story here is actress Gina Carano, former MMA fighter turned actor, and played I forget the name of the character, played one of the mercenaries in The Mandalorian, and she also played one of the villains in Deadpool, is what I've seen her in, basically. Seems pretty good actress. She apparently was fired from Disney as a result of some political statements she made on Twitter, or sorry, X. Fun fact, every time you search Twitter in Google and get X, Elon Musk cries. I'm joking, I don't know if he does. Okay, but yeah, that's basically what she's got fired for, is some political statements she made on X, and not only did they fire her, but they tried to make it harder for her to find work in other contracts and stuff like that. At least that's what's being told according to what's on the public documents for it. Those of you listening right now who know me in any regard, whether you know me from YouTube or know me privately, you probably know that if there are two things in the world that I care about really deeply and really passionately, it's Star Wars and actresses who file lawsuits against Disney when they're mad at them. Alright, okay, so I do have a May 4th special that I do on my other channel, Planet Weird. I didn't do it this year because I was too high. No, I'm just kidding. I just forgot to do it this year. But in this particular case, an actress who played a character in Star Wars who's now suing Disney actually does have some relevance to some strong social and political issues that have already been getting talked about for some time. The issue that's been getting talked about over the last few years of people getting fired from their jobs for exercising free speech. But how can this be possible if free speech is protected by the First Amendment? Well, it's only protected in certain situations, is really the answer there. For one, there's the obvious exception for when it falls outside of reason, like yelling bomb on an airplane or something. Sexual harassment, not protected free speech. Child pornography, obviously not protected free speech. But it starts to get into more of a moral gray area when we, look at the fact that the First Amendment actually specifically says that the government cannot infringe on free speech. It doesn't say anywhere that a private corporation can't do it. A similar loophole allows for the creation of organizations such as the FCC or the SRB and other agencies that regulate communications. And I'm not saying that, video games, movies, or, social media should be regulated, but the loophole that allows them to exist is that none of them are actually government organizations. They're all private organizations, wink wink, that get a lot of support from the government but are not the government, wink wink. And the First Amendment is not actually the only right that has loopholes like this. A very similar loophole exists that allows law enforcement agencies like the FBI and other agencies like the NSA to get around the Fourth Amendment's requirement for lawfully obtained warrants for searches and seizures. And the loophole is that the personal information or personal private data that they're obtaining is collected through a third party or a private organization or a private person, like your phone company or your credit card company, or in some cases, I've heard at least, a hacker who puts malware on people's computers. While things like this are being debated in Congress, law enforcement is generally considered to be blameless with regards to the Fourth Amendment, at least, if a third party gives them information unlawfully. They can use it as evidence. And plea bargains kind of, let you waive your Fifth Amendment rights to not be a witness against yourself. So yeah, it's not the only exemption that's that exists that is technically taking a right away in that manner of speaking. But this is one that's been talked about very frequently, and that's where problems such as the one Miss Carano had happened. If an employee is seen saying something on social media that conflicts with their brand image, conflicts with, some ideal that that company holds, they can fire them for it, and it's legal. Many celebrities in general have this problem because they work in Hollywood, which is based in California, which is actually an at-will state, meaning that if you're an at-will state, you're basically in a legal system where the company you work for can fire you for any reason or no reason, and it'd be legal. So she would really have had the right to sue for wrongful termination, as they keep saying she did in these articles. That's basically why I started looking into the court docs myself, and I'm like, wait, she wouldn't have a case. Why did she sue for that? But with all the screenshots she wound up posting about the harassment she was getting on social media, she did wind up getting a pretty strong case for discrimination, not against her, not just for her political views, but because she was a woman, and because male employees were posting very similar things that she did and getting no retaliatory action whatsoever. Going off the screenshots of some of the interactions she had on X that she sent to the court for the lawsuit, it seems like she spent a very long, considerable amount of time between the months of August 2020 and November of 2020 with various people on social media insisting that she put pronouns in her profile name and start saying, BLM and things like that were all correct, even though she did not necessarily agree with those views. And then when she expressed that she just didn't agree with those views, they kept accusing her of being racist and being homophobic or transphobic, and she kept explaining that she wasn't. She just didn't see the point of pronouns or didn't really agree with some of the political blah, 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 blah. She got harassed over this online for this specific set of political views in a period that seems to have lasted close to 3 or 4 months. At a certain point, she responded to a lot of this with by updating her profile name with joke pronouns, saying that her pronouns were, beep, boop, beep, like, the droids from Star Wars. And this pissed him off even more, and I don't understand that part of it, to be honest with you. Like, alright, fine, so she don't do pronouns. I mean, it's like, it's not that unusual or even hurtful, really, to use joke pronouns, Not that I know of, anyways. I've heard of hate crimes. I've never heard of a hate crime that was inspired by somebody who just didn't want to use pronouns. That doesn't make any sense to me, really, honestly. FYI, my pronouns are this, that, and these. Yeah. And then she finally snapped and posted a picture comparing her situation to Jews in the Holocaust, citing that, the very true, reality that before, soldiers were able to just go around people up, they had neighbors hating them, people that were just there that hated them for whatever reason based off that rhetoric. And she basically expressed that she felt the same or a similar thing was happening to her or to people who did not agree with the status quo of, what would be the status quo at the time, politically speaking, with all this wolf culture of pronouns and blah, 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 blah. So, so that final thing, that final post that she posted about the Jews and the Holocaust was apparently what Disney had fired her for. This is what was shown in the complaint that she initially filed against them. It's kind of hard to tell what the discovery process actually discovered, because a lot of the court filings were things like, people trying to get lawyers approved from out of state, or Disney filing 10,000 motions to have it dismissed and getting rejected. That sounds shady. What else was there? One of the magistrate judges got recused from the case. Refiling transcripts, filing the same motions over and over again. I think the Huckleberry Studios, the film studio that filmed Mandalorian, I think they were given like some kind of waiver of the summons because I guess they didn't do anything in regards to that. But Disney kept asking for continuances and extensions on everything. Then they filed some kind of motion to try to get a protective order so they would only to limit the amount of information they had to release to the court, claiming that it was, they didn't want to give away trade secrets or whatever. They kept trying to get the trial pushed to a later date. And like I said, a lot of this was the defendants filing the same motion multiple times, while they kept changing counsel and reapproving other lawyers. Is anybody else getting the impression that they might have been stalling? Because I sure as fuck did. Seems to me like if they knew they were innocent, yeah, okay, they probably still would have wanted the protective order, for not giving away insider info or something. But I mean, seems like they would have been a little more cooperative than this if they knew they didn't do it. Yeah, I would think. I don't know. Generally speaking, that's what usually happens if you're in a position of having to sue a large corporation for something. Even if your grievances are justified, they generally do draw it out and then offer a settlement, like that. But in this case, it seems like she might have actually had them by the balls on this one, which is really the part that makes it interesting. And Disney ultimately opted to settle out of court, and going off the motions that wound up being filed towards the tail end of the case, a whole series of motions to file protective orders to, protect them from having to release company secrets, and the court's response to a motion to compel evidence, in which the determination of the court was that the only documents needed to prove Gina Carano's allegations were financial related statements so that they know how much money to give her when they rule in her favor. So yeah, it sounds like, sorry Disney. So it more or less ended the same way some of these other lawsuits, like with Paramount and others, with Disney just offering a bunch of money. This could be potentially the start of something that could end up creating a legal precedent for people who get fired for what they say on social media. So that while you can't sue a private company for violating First Amendment rights, you can sue them for things that are already laws protecting their employees, like discrimination, harassment, etc., and things like that. And this appears to be a case where those were one and the same.
Important it is to stand up for free speech. Read further. Smoke with your much irritized.
Yeah, I think my throat might be too dry for all these impressions, if I'm being honest with you.